So my name is Hunter Freeman. I'm an intellectual property attorney with Kim & Lahey, and a lot of what I do is I help clients utilize the rights surrounding their branding and innovations to keep competitors out of the sandbox, so to speak, while they gain and maintain market share. One thing to know about Kim & Lahey is that we have 5 different patent attorneys. We have an emphasis on AI and software patents. We have a software engineer who turned patent, as well as computer science majors and physics majors. So, but the most important part about our law firm is that a lot of us are small business owners in our own right, outside of the law. So we understand what it's like to run your own small business. So, but that's not why you came here. You wanted to hear a little bit about IP and software, but just know this disclaimer means I'm not actually giving you legal advice. If you want that, I'm happy to talk to you, but today is not the legal advice. So what we will talk about is a little bit of IP considerations, like the primary forms of protection for software. We'll talk a little bit about AI, open source, and then contracts. So there are 2 primary types of intellectual property. Well, there's really 4, but there's 2 that we'll talk about today. So you have your patents, which protects the functionality of an invention. You've got your trademarks, which protects your branding or your marketing. You've got your copyrights, which actually can protect your code. And you've got your trade secrets, which is the secret sauce, the know-how, whatever it is. If you figure out how to solve a problem that no one else knows how to solve, that's your trade secrets. But in terms of the 2 big types of protections that mostly go with software are patents to protect the functionality and the copyrights to actually protect the source code or object code from being copied or replicated by customers, competitors, whoever. So they protect different things, the patents, the ideas, the copyrights, the actual written code, and they require different showings in order to get it. So patents there's 3 different types, but really only one that you care about, which is utility patent. The requirements to get a patent is that you have to have an innovation that is novel, meaning no one else has done exactly what you've done. It's non-obvious, which just means that the changes that you have done over the prior art and the prior software are not merely trivial changes, and it's got to be useful. And so if you're able to get a patent, you can stop other people from making, using, selling, offering for sale, or importing software that falls within the scope of protection that you're entitled through your patent. So let's talk a little bit about what novelty and non-obviousness looks like. And I know that we're not in the mechanical world, but it's easier to show you in the mechanical world than in software. So back in the 50s, 60s, they came up with the roller skate, a shoe with 4 wheels and it rolled, and that was novel. No one had ever done that. So certainly it got a patent. Well, back in the late 80s, early 90s, they came up with the rollerblade. It's still a shoe and it's still got 4 wheels, but they said, you know what, the changing it from the rectangular configuration into the blade formation, that's new, and it's not an obvious change of what was previously done. So it was able to get a patent. But then Nike came along, and it basically it's hard to tell, but you can see the 2 back wheels. There's actually 2 right there, and then there's the 3 in the front. And the patent office basically said, look, you took the roller skate back half and you took the rollerblade front half and you put it together. No patent. So that's an example of what would be non-obvious versus obvious. So the second form of protection is the copyright. So again, this isn't protecting the ideas that are embodied and carried out by your software, but this is the expression of the idea, meaning like the actual code. And so this can be very useful for you, especially if you've got client-facing software where your customers are going to actually have access to your software, as opposed to like a SaaS model where you're keeping complete control and blocked off. So what the copyright will do is it will prevent other people from reproducing, displaying, distributing, and modifying that software. So that helps you from people taking your work and then trying to turn it into your own. So the key things that you need to know about copyrights is, one, they're actually pretty easy to get. You just have to be original and it's got to be fixed in a tangible medium. But obviously software, is in a tangible medium, and if you're writing it as opposed to replicating it, then it's going to be original. The other thing that is important to know is the ownership rules. So the copyright rules say that the author of the work in question is the default owner. But what is an author? Well, it depends on whether you're an independent contractor or whether you're an employee. So if you're an employee and you create the work in the scope of your employment, your employer is the author. Your employer is the one who owns that work. But if you, for instance, own your own company and you're being hired by a customer to, design a website, write software, do whatever for them, you're now an independent contractor for that customer. So you own the code. But it also goes both ways, because if you hire an independent contractor coder to help you write this, you've got a couple of different issues. One, are they an author? And if so, is it a joint work? Meaning, if they're an independent contractor and they're simply helping you, now do you both own this copyright? And if that is the answer, that means that you can both independently promote and use the copyright and exploit it however you want. You just have to go back and account to one another for the profits you made. But that's probably not what you want. So you either need to make sure that you're hiring employees with you to write this code, or you need to make sure that you're getting something in writing that says, hey, look, at the end of this, if you pay me everything, you're going to own it. And that's the same thing that a lot of times customers will want, is say, well, look, if I'm paying you for custom software development, I want to own this at the end. That's fine. That's a business negotiation. But what you can do is you can use your copyright to ensure payment. Because what you can do is say, hey, look, I'm going to own this copyright until I get my last paycheck. Once I get that last paycheck, I'll turn the copyrights over to you. And you can even have your contract so that that happens automatically upon receipt and or deposit of the last payment pursuant to the contract. So it's just another little tool to make sure that you get paid for the work that you do. So between the two, you've got to pick which, well, you don't have to. I mean, you could theoretically go for both, but most of the time you're going to pick one or the other. So patents or copyrights. So a little bit of a compare and contrast. So patents have a high bar for protection. They're hard to get. Whereas copyrights have a low bar of protection. They're very easy to get. Patents take about 2.5 to 3 years to get, and they last for about 20 years. So if you have a product whose shelf life is 4 years, do you want to spend 2 of that trying to get your patent, or do you want to spend about 3 months getting your copyright? So you've got to think about what the shelf life of your product is. And they protect the different things, as we talked about. The patents are the functionality, so it doesn't matter if anyone even knows about your software. If they come up with a piece of software that does the same things that yours does, they potentially infringe your patent. Whereas the copyright, they only infringe that if they know about yours and they're trying to copy it. So as you can think, patents, from just that alone, patents are good to keep your competitors at bay, right? So you've got people trying to write similar software to you, and you want to put up as many roadblocks as you can to prevent them to get your own little monopoly for your software. Whereas copyrights are better for your customers. Because you sell your customer, you put use restrictions, you say you get 1 copy, all of a sudden they have 100 copies, they're modifying it, you're wondering why they never call you back, you're like, I wonder whatever happened to that, and they now have put your software everywhere. And so those are the types of considerations that you need to think about when you're deciding, do I want to go the patent route or do I want to go the copyright route? For instance, like if I was doing a SaaS product, I'd probably think, between the two, I'd probably think patent, because my customer's never going to gain access to the object code or the source code, so there's very little chance that they're actually going to get to copy it. But my competitors are going to see this SaaS model, they're going to see what the software does, and they're going to say, I can write that, I can do it better. So you want to put up a roadblock that prevents them from writing another piece of software that does what yours does. Moving now to open source. The one thing that I want to talk to you about a little bit is just be very careful about knowing what your license says for the open source. There's the permissive or the restrictive, and you need to be careful because the restrictive basically says, look, if you incorporate this open source into your code, you're giving up your rights in your original code, you're adding to the open source library. Probably not what you want. So just make sure that you know which open source that you're looking at. The GPLs and the GNUs are typically the ones that have the restrictive language in there that potentially you could be giving up your rights. So just know. That's all I'm saying on that. Since we're here talking about software, who cannot talk about AI? But what I want to talk to you a little bit about is how AI can affect your rights. There are some pitfalls that you need to be aware of. AI is a great tool, but there are some restrictions on it. And that is, if you use, especially generative AI, if you use generative AI, you might be giving up rights to what you create, because the rules are that only humans can be authors or inventors. And the first case that actually came up on this was, you remember the monkey selfie? That was the case that brought all this together. The monkey took a picture of himself, and then that picture started going viral. The person whose phone it was said, I own that picture, everyone's got to pay me. And the court said, you didn't take the picture, the monkey took the picture, and a monkey's not a human, the monkey can't own the copyright, so no one owns the copyright. So they took that logic and moved it right on over to AI. And they said, same thing. It might not be a monkey, but it's AI, you didn't write it. The AI wrote it, so you can't own that. Now the question becomes of what happens when you incorporate AI, but you also have your own original stuff that you're putting in there. Where does it fall? Like, do you get to some protection, and how do you split it? Like, what's mine, what's AI's, how integral is it? Can I separate the two? So just be careful if you're going to use generative AI. Just know that you may be losing patent and or copyrights on that. Another topic that I wanted to talk to you a little bit about is software contracts. And so having your own standard contract is really important because then you know what you can, well, first of all, you know what it says. Second of all, you don't have to call a lawyer every time that you have a contract and have it renegotiated, because you'll know what's in the contract and you will have written it so that it benefits you. And by knowing what's in it, you'll know what you can give on and what you can't. So you don't necessarily need to call the attorney every time that you have a customer who's requesting a change or something like that, or even worse, a customer who's giving you their contract. So it's a good investment to up front have a standard contract that you use. And there are several contracts that you should think about. Like, one, what's the contract that I use when I'm hiring an independent contractor to help me? And certainly you want to have some sort of confidentiality provision in there. You want to have some sort of assignment provision in there to make sure that you own everything. Another type of contract that you want to have is with your employees. So now we're actually starting to get into employment law a little bit. But so remember when I talked to you about trade secrets, the know-how, the stuff that no one else knows, you've solved problems, and the way you go about things, and your confidential information about who your customers are, what their ordering patterns are, and what their needs are, and things like that. Well, unfortunately, employees oftentimes former employees become competitors. And so that confidential information to which they were exposed throughout their entire employment now gets used against you. And just recently, the Federal Trade Commission came down and they said you can no longer have non-competes, which just basically says, for X number of years, it used to be in South Carolina that you could tell someone, a former employee, that once they left your employ, for a reasonable amount of time, within a reasonable geography, they couldn't compete against you. They just couldn't do it. So you could say the standard was kind of like within 50 miles for 3 years, you couldn't work in a particular industry or something like that. And so the courts would look at it to see, well, is this reasonable? Like, because you can't just say you can't be a coder anymore. I mean, the courts aren't going to let you put someone out of a job. But the FTC came down and they said, no, actually, we think that non-competes actually hamper global and national competitiveness. You could debate that, but that was their opinion about it. So they said, you just can't tell people that they can't compete with you. Can't do it at all. So what do you do now? Well, you can, that means you can't put up a wall, right? A non-compete is just a big wall that says, you can't do anything that competes against me. So now you actually have to use a fence with pickets where there are some openings. But the more pickets you have and the closer they are together, the more it starts to resemble a wall. And so you want to have things like your confidentiality agreement that says, hey, look, you're going to be exposed to confidential information while you're here. That could be financial, that could be customer lists, that could be revenues, that could be future product development, that could be techniques that we've developed. Any number of things. If it is not, not generally known in the industry, that's your confidential information, and you can prevent them from taking that with them. Another thing you could do is have a non-solicitation agreement. So while they do get to go work for your competitor, they don't get to then start calling on your customers. Now, you can't necessarily say you can't call any of my customers, but you can do things like any customer with whom you've had contact with while you worked for me, off limits. Any customer you learned about while you were with me that you knew was one of my clients, off limits. So you can start doing things to try to really hamper their ability to compete. You can't cut it off, but you can certainly hamper it. So those are some types of internal agreements that you're going to want to have. Some external or client-facing contracts you're going to want to have are obviously your master services agreement or some sort of customer contract. In addition to taking care of things like what happens in a dispute. So anytime you have a business relationship, there are always business risks. Like something could go wrong, right? So what I like to do with my clients is play the what if game. Well, what if this happens? What do you want? What happens then? And I ask them how they would like to resolve all these things. Like, what if the worst case scenario happens? What do you want the answer to be? Well, you put that in your contract. And you say, when this happens, this is how we're going to resolve this. And so you can put a lot of those types of things that all benefit you. So what are some of the things that you would want to put into a contract? Well, the first is ownership rights. I don't care whether you're talking about development contracts or we'll talk about licensing and subscription agreements here in a second, but you definitely want to say, look, I own this stuff. Unless you want to give it away, and then you say I own it until I get paid in full, and at which point I give it to you. And then you want to, well, let's turn to development contracts for a second. So you want to have your milestones. When am I going to get paid? What are the milestones I have to hit? Let's define that very clearly, because I will tell you in development contracts, the dispute always comes up about whether or not it works. And so you have to have very clear terms about what acceptance is. And generally that contract makes or breaks who wins when a piece of software doesn't work to the customer's satisfaction. The first thing I always look at when a developer or a customer end user comes to me and says, this software isn't working, or my customer is being a jerk about this, he keeps changing the terms on what he wants it to be, I'm going to say, well, look, there should be a very easy way to decide this. You should have had all your development milestones and deliverables set forth. So if it hits the deliverables and it provides the functionality set forth in there, then you're great. And then you have your acceptance and testing. So it's very hard for a customer to complain, hey, this doesn't work right, when you say, well, I gave it to you. I gave you that testing period. You tested it. I even helped you. And then you signed something in writing saying, yep, this does exactly what I said it wants. 6 months later, they come back and says, well, wait a second, this isn't doing what I want it to do. Well, it's doing exactly what it did when you signed the acceptance. So you want to take a look at some of that. And then you also want to deal with some of the warranties. You know, what happens if you know, bugs or errors comes in. Most of the time you want it to have some sort of repair and replace type thing of saying, look, I will go error fix this, and if I can't, then we'll, you know, maybe give you a refund. But you want to cut off any ability for them to try to come back and claim damages from you. You want to say, look, at best, you're going to get a refund, but preferably I'm going to do my error fixing, and that's going to be it. And most of the time, that's going to be contingent upon your maintenance agreement, and say, look, you have to be part of the maintenance agreement. So those are some of the things that you want to consider. But when you're dealing with a development thing, a development contract, you want to put together that do all of your data collection and put together all of your objectives and your deliverables, because that is essentially going to be the definition of whether or not you met your contract. So, you know, all the addendums and exhibits that you use the early on when you're doing all your data collection, when you're doing all your data flow and saying, okay, this is the functionality that it has to have. Be sure that you get all that and put that in the contract, because that's going to define exactly what it is, and then it doesn't become a he said, she said about what the software is or is not supposed to do. So let's talk a little bit about subscription agreements and license agreements. As I'm sure you know, when you're dealing with a SaaS model, you're housing all the software, you're housing all the data. That's all residing either on the cloud or on a server that's within your control. But what it's not doing is it's not residing on the software, and the data is not residing on the customer's server or anything, which, you know, it has its benefits and its downfalls. But a license agreement is more along the lines where your software is now being delivered to the customer, and they are downloading it onto their server, their machines, their whatever. And so it poses some different questions and you can also have hybrid models, obviously, where, like Office 365, where, you know, you can get it either from the internet or you can get it from your local copy on your hard drive. So when you're dealing with a SaaS model, probably the number one issue is going to be all about data, because the client is now concerned that their data is now being exported onto the cloud or to your server, but it's not in their control anymore, or not exclusively within their control. So the first thing that the client's going to have, or a smart client's going to have, is concerns about security and data loss. And so your contract really needs to detail what that's going to be. And what the remedies are going to be. More importantly, what the remedies are going to be. So, you know, because a lot of people, you're probably not using your own servers. Okay, you're probably not using your own servers. You're probably hosting this stuff in the cloud, and so you need to, you know, alert the customer as to, you know, what the data security provisions are going to be. And more importantly, what's going to happen should there be a data breach or should there be a data loss. Then another question about data is data ownership. Most of the time in SaaS agreements, the customer client data is theirs. But oftentimes you want to be able to use that data to improve upon your models, and for, you know, a number of reasons. So a lot of times what you want to do is you want to reserve for yourself the right to keep one copy of the customer data in an anonymized format, so that, you know, it can't be traced back to your customer or any of the end users, but that you can use that for, you know, maintenance purposes, improvement purposes, or whatever other purposes that you want. The last data issue normally, and a lot of people overlook this one because they just, you know, it's on the tail end. It's when the contract is terminating, and when you're entering into an agreement, you never think about, well, what happens when the agreement ends? But that's the data export and the data conversion cost. Who's going to be responsible for that? You know, the clients obviously, you know, especially if they are firing you, they're going to say, give me back my data and pay for it to be in a usable format and stuff like that. this is one of those situations where you want to have that in writing that says, look, if this contract terminates for any reason, including you're firing me, that's going to be on you. Like, I'll get you your data, I can export it to you, but I'm going to export it to you in the format in which I have it, and then you're going to have to pay all the conversion costs for getting it into another format, for your next vendor, or let that other vendor take care of that. Some of the add-on services, training, customization, you're probably going to need some sort of maintenance agreement, or the training services. So just outline, does it have to be in person? Can it be remote? How many hours are they going to be entitled to for training? What hours of the day? Is it going to be internet, phone? You got to think through those logistics so that you're on the same page there. And then the use restrictions. So I'll talk about use restrictions also with the license, but they're slightly different than what I'm going to talk about over there. And this is, can they use that SaaS model for internal purposes, or can they then allow customers to use this? I've seen a customer that tries to use this and then kind of use it as a downstream service. And you probably want to prohibit that, because that downstream customer could have been your customer. But you just have to work through those things and figure it out. And then obviously credential sharing, how many users are you having, and how are you going to control that? So you got to put all those things in your agreement. So now let's switch over to license agreements, where the software is actually getting into the possession of your customers, which is always a scary thing, because you're giving them the software. Now you got to think about use restrictions in terms of what can they do with the software. So how many copies can they make? How many machines can they run it on? How many users can they have? Do you have the right to audit that? Like, how do you keep up with that? Do they have to send you a report on a quarterly basis? What are you doing to monitor that? Obviously, you want all your reverse engineering, decompiling. You want to make it so that, if they even try to get to your source code, that's an automatic termination type thing, because, they don't need to be getting there without your written authorization. And then certainly, you don't want them modifying this too much and using it with other systems about which you don't know. Because what happens if they have their own software, or someone else wrote some software that they want to use in conjunction? All of a sudden they get this nasty gram saying you've infringed my patent, and it's not really your software that they're complaining about, it's the combination of your software with their software. And so you want to deal with things about, like, okay, how are you going to be using my software, and how is that going to affect me? And then along those same lines, you have your indemnification clauses that say, look, if you're using my software in an unauthorized manner, or if you're modifying it anyway, and someone gets unhappy about that, and they sue me instead of you, or they sue both of us, you're picking up the tab on that, because that wasn't my fault. And then you've got your typical warranty type of issues with license agreements as well. So that really are the main topics that I wanted to talk to you about today, but I wanted to leave a little bit of time for any sort of questions or answers that you might have.
So reverse engineering, like if you compile the code, do you prevent somebody from compiling your code?
So the question was, what do you do to keep people from decompiling the code? There are a couple things that you can do. The first thing which we did talk about is you can put your contractual provisions in there that would make that a breach of contract in order to do that. So if they do that, that's a terminable offense. You could put in your contract, like, look, and we're also going to have these liquidated damages. That means, like, if I find out you did this, you have to pay me like $5,000 or some amount of money. But another thing that you can do is that you can put a technological measure in there. And the cool thing about doing that is it doesn't have to be foolproof, because the DMCA, they call it the Digital Millennium Copyright, basically says, look, if you have put into place reasonable technological measure to prevent that, and someone circumvents that, they can get sued and for doing that. So the Congress has helped you out a little bit there.
So, hypothetically speaking, first question, how would somebody know, say, ChatGPT generated the code? And then the second part is like, is there a distinction between AI and AI assistant, for example, like let's say it helped me think about what data structures I needed, or what the architecture might look like?
So how does someone know? Like right off the bat, no one's really going to know. But here's the problem: when you find you get into a dispute with someone, and you then have to file a lawsuit. Well, during that lawsuit, you get to engage in all sorts of discovery, and you get to take forensic copies, and you get to start looking into this. And they get to ask you under oath, like, did you use AI? And unless you're going to lie about it, you got to say, yeah. So that's when it's going to come out, when it's the most important, right? When you're really trying to enforce your rights, and you spend all this time and money only to find out, steps away from the finish line, oops, you don't go back to go. Don't go straight to jail, don't pass go, no $200 for you. But what happens in the situation, look, if you're just getting architectural, if you're getting the ideas from AI, but you're not actually getting AI to write the code or write any of that stuff. I mean, that's the same thing as me saying this is how I would do it, and then you go write the code. There's nothing wrong with that. But if I sit there and tell you, here's the code that you should be writing, then I'm actually going to own that copyright, not you. So it'd be kind of the same thing. And thank you so much. I'll stick around, but I think we're out of time, but I'll be happy to stick around and answer any questions that anyone has.
Thank you so much.
Thank you.